Welcome to a special midweek, I guess Wednesday, hump day edition of the David Pollack Show. I'm giving you a special treat today because, of course, today was day one of jury deliberations in the Trump hush money trial. That's right, the business records case, Alvin Bragg's case in New York City. And I need to get you guys up to speed. If you've been on social media, you've been watching news, I'm sure you heard a lot of information, and you want the quick hits, everything you need to know. So when you're sitting around the water cooler, if those things still exist, you know what you're talking about, and you're educated and informed. And so for us to have this conversation, I'm bringing my good friend back, Ryan Vescio. Ryan is a senior counsel at the firm of Sheffield Lohman. Just sounds fancy. Like if I was going to need a lawyer, I would want a lawyer from Sheffield Lohman. Like I can see the guys showing up in all the suits with the heavy feet, you know, walking in like briefcases, and then they just give away the case because they're like, no way we're going to beat these guys. He's a senior counsel over there. He's also was a state attorney for 15 years, prosecuting major crimes, including high-profile murders, child trafficking, and horrible other types of cases involving children. The dude knows his stuff. He's been in trial a lot. And so I knew, Ryan, you would be able to give us some information, and a non-biased information, just so my viewers know this isn't a lifelong Republican Trump supporter guy that I'm bringing on here. This is an objective attorney who doesn't necessarily love the guy. So you know the information you're getting from him is no BS is what you get here. I love Trump, just for the record. But I want you guys to get the full information. But now I'm bringing in another special guest tonight for this panel because, look, I'm a lawyer. Ryan's a lawyer. Ryan's a much better lawyer than me. But some of you at home may not be lawyers. And I don't have a layman, but you know what I do have? I have a dummy. So I thought I'd bring in my dummy, Puppet Carlson, to ask the questions that maybe non-lawyers would want to ask. You know, you might say something like, what's a trial? You never know what's going to come out of this puppet's mouth. But Ryan, I want to introduce you to the infamous Puppet Carlson. And Puppet, welcome.
Thank you, David. Thank you, Ryan. Nice to see you, Ryan. Nice to meet you, Ryan.
It's good to meet you after that introduction that David gave me. I hope one day I could be as esteemed as you and be made of felt and have somebody with a hand up my ass telling me what to say. So,
well, you know, much like most of the other politicians in Congress, I too have someone pulling my strings, if you know what I mean. And I would say that David is my dummy more than I am his dummy. I am the puppet, and I am the man on this show. That is faux show.
You know, Ryan, we talk a lot about exactly what you say. We call it his manhole. We say he's controlled by his manhole. And, you know, it's a topic of conversation. Puppet suggests that I'm a little bit too obsessed with it. I just like to point out, exactly like you said, that he is controlled by somebody with their hand up his manhole. So everything he says, you have to consider, you know, that's who's behind the man. Nobody has their hand up my manhole. I'm just me. So that's Puppet's credibility.
At least I make it known that I'm being controlled, unlike those in the White House.
Well, that's true.
Well, I mean, look, David and Puppet, we're all driven by things that set us forward and allow us to get through the day. And who am I to judge who's controlling what? So I just try to keep the wheels on the road, and I'll let you guys decide who's the dumber out of the two of you.
No, that's so nice. See what a good litigator he is. He already convinced this jury that he won. Let's go talk. Let's not waste any more time. Get right about it. What's going on today? So today was day one of deliberations in the hush money case. I'm going to give the fast forward 30-second update to anybody who is unfamiliar, because actually I was talking to one of the young trainers in my gym today, and I was like, hey, I was on my phone when I'm working out, and he's like, what's going on? Taking a break? I'm like, well, today's kind of a big day. The jury just got sent for deliberations. And he's like, oh, what case? I'm like, oh, you know, the Trump case in New York. Oh, what is he being accused of there? I'm like, you don't know about the Trump case in New York? He's like, no, I don't. It occurred to me that only dorks like us are paying attention, which is terrifying, considering this is one of the most historic prosecutions ever in history. But there are people who have no idea what we're talking about. Now, the people who have no idea what we're talking about are probably not watching this, but maybe this dude's like, hey, I'm going to go check out what David has to say about it. Or if he texts me, he's like, well, what's the deal? He can watch this 30-second, super fast, Micro Machine, now you're up to speed summation that'll bring us. Are you ready?
Let's go on the clock.
When Alvin Bragg ran for office, he vowed he was going to get Trump. He decided he was going to go and bring a very weak case against him involving business records, involving allegedly a hush money payment to a porn actress named Stormy Daniels. Michael Cohen took it upon himself to pay this lady named Stormy Daniels. It was put in a book called Legal Fees, which is what it was because he was a lawyer. The FTC investigated this. They said it wasn't going to be a crime as far as federal election standards. It didn't matter. Alvin Bragg charged him anyway, charged him with 30-something felonies because they said he falsified business documents, and he said he did it with an underlying intent to interfere with an election. Now we've moved forward. We have a bunch of interesting witnesses, including Stormy Daniels, Michael Cohen, who admitted he took money and acted on his own behalf. And then we had some interesting testimony by a guy named Robert Navarro, who said that Cohen's basically a liar. The judge didn't like him very much. Then they went up, came back after a long Memorial Day weekend, and now they've given a crazy instructions to the jury, and now they're deliberating. Now you're up to speed.
Wow. I won't tell you that was 32 seconds, but I'm just glad you didn't pass out during that.
Well, nobody has ever complained of getting 2 seconds past 30 with me. So, all right. So now we're at the jury instruction.
About getting 2 seconds with you at all.
Oh, I think the complaints begin before the seconds start.
That's for sure.
So now we have jury.
You should stop trying to stick your hand in the manhole.
You know, sometimes you just settle for anything warm and sweaty, right, Puppet? So we're deliberating. We're deliberating in New York City. The jury has been sent back, and I have some questions for you, Ryan. I'm sure after this exchange with Puppet, people are going to have a lot of questions for me, but that's a different show. I'm bringing you on because you are the trial guy, and you are the one in the no BS zone. You have nothing to gain from having an opinion one way or the other. You're just going to give the facts. And so one of the big controversies that came out today, actually, let's back up just a little before I talk about the jury instructions. Did anything, because it was a 6-hour summation by the prosecution. It lasted, I think, 2 days, basically. Mm-hmm. It was a 6-hour summation. I asked friends of mine who are lawyers, hey, 6-hour summations, does that usually mean you have a good case or a bad case? The opinion was jurors are bored by 6-hour summations, and you most likely are losing them if you have to go on that long. And if you're able to easily prove your case, you don't need 6 hours to make your point. What is your opinion about the 6-hour summation?
Well, look, it's too long. And, you know, when you put President Trump's attorney at his end, it's over 10 hours. And, you know, there's a few things. First of all, by the time you get to closing arguments, jurors have basically made up their mind. And very little that is told to them in closing arguments really sticks. You know, the second thing is this. In 10 hours, you could read a third of the Bible. And to go on that long, people don't like attorneys talking. People don't care what attorneys have to say. You're right. You lose people. You know, the other part is this. Although the case has a little intricacy to it, this isn't the most, comprehensive, confusing case ever. It's, did he make the payment? What was the purpose of the payment? And was he trying to avoid some other crime? I mean, that's it. So, in my opinion, if you can't tell that story in 45 or 60 minutes, you're just going on and on and on. Jurors take notes the first half an hour, and then they eventually tune out because their hand is cramping and they start staring at the ceiling.
And a puppet knows a lot about hands cramping. And
That's right, I do. And I can tell you for sure, a 10-hour summation, that would be like listening to Michael Cohen's testimony for 10 hours. I mean, it's just a bunch of crap.
So, it's all right. So we get through the summation, and I agree with you, Ryan. I think that a 6-hour summation is suggestive of the fact that you really are trying to throw a lot at the wall to see what sticks. I mean, fine. But maybe not. We can't just assume. Maybe they did a really good job and they crossed all T's and dotted all I's.
I think there's another thing, David, on that. Yeah. And I think it's been true throughout the entire trial. Look, trial lawyers love to hear themselves speak. And you get on the platform of probably one of the largest criminal prosecutions in the history of our country. And sometimes you're your own worst enemy. Just as Trump's attorneys went a little, far sometimes in cross-examinations, and just as the prosecution in its cross-examination of the sole Trump witness went a little bit too far, there's a point in time to where it's not about you as the attorney, it's about your client, it's about your case. And I think both sides love to hear themselves speak and thought that people cared what they were going to say for hours and hours.
No, I agree with you what you're saying. And also, compare that to Trump's team. I mean, they didn't even put Trump on the stand. They're pretty confident at this point, I think, that the government hasn't or the state hasn't proven their case. So now we give the instructions to the jury. Now, the big thing that came out today was in these instructions, which were very complicated, apparently. And we talked about this, I think, the last time we were on the show, is that there's no standard instructions for this type of case. Now, there are sort of model instructions based on what the what the elements of the crime are. But because this has to deal with so many different types of situations, kind of a novel prosecution, they've had to come up with these jury's instructions that both parties agreed to. Okay, and this is what it's going to be. Apparently, in these instructions, it was explained that the jury didn't have to be unanimous on the underlying crimes. And a lot of people were calling into question, saying, since when in criminal law does the jury not have to be unanimous in an underlying crime in order to be unanimous on the, I guess, primary crime? Could you explain a little bit what in the heck they're talking about with this?
I will, and I'll try to keep this simple enough for 12 puppets on the jury to understand. So
12 angry puppets.
Yeah.
So the people's case comes down to the fact that these payments were made in furtherance of another crime. So you got two levels of crimes here. And what the grand jury and the people had said is that they allege that President Trump committed one of three underlying crimes. And what the instruction said was that all 12 jurors didn't have to agree which of the three underlying crimes was committed or proven, just that one of those were. And it is confusing from a layperson's perspective, but you think about it this way: the people's case is like a layer cake. You have to have the first layer, which is you did something wrong, and then you had to have done it for a certain reason. So no matter if the filling is chocolate, vanilla, or strawberry, the cake still has a filling, and the people have to be able to prove that beyond reasonable doubt.
So Puppet has a filling too. He's actually made of a MyPillow. A lot of people don't know this. And he was born in a MyPillow factory, just so you know. Mike Lindell one day wanted a real conservative boy. And so out of his wish on a falling star, Puppet was born out of the MyPillow factory. And he was lost for a few years. He traveled through the candy cane forest and all of that stuff. I mean, all that stuff, like whatever happened. Anyway, in some other movie that sounds very similar to Puppet's origin story. And then he found his way here at the David Pollack Show. We found him on the street in a trunk. We've cleaned him up. And so speaking of layers, Puppet has layers. And I just thought you should know a little bit about his backstory, because it might make a good children's book someday.
Foam, fabric.
Right.
It's amazing for him being a MyPillow. He sure isn't lumpy.
Well, he is. He is lumpy. We put him in the dryer a lot, and it fluffs him. But if he doesn't get dried, he does get quite a fluffy. So the instructions go to the so one of the interesting things that I found, though, with that they don't have to be unanimous on the underlying crime. The thing is, though, in order for this to even be a felony, the business record falsification, which I don't even think they proved the business record falsification based on Michael Cohen's testimony that he was kind of acting on his own to begin with and was stealing from the organization. But let's put that aside. And Navarro's testimony is basically saying that he was acting on his own. But whatever. Putting that aside for a second, in order to get the felony proven, though, there has to be an underlying crime, and the business record falsification was to conceal the underlying crime. And like you mentioned, you said, well, there's several theories of what the underlying crime is. But is a trial where the president of the United States for the first time in history is a defendant, is that the place where you kind of just figured out on the fly? And the thing is, there is no conviction, right? He wasn't charged with any underlying crime. Not even in this Alvin Bragg case. There is no charge of an underlying crime. The only charge is falsification of business records. And the only reason why they got past the statute of limitations and the only reason why they got to the felony was because they alleged that there was an underlying crime that they were trying to conceal. And of those, I think the more significant one was an alleged FEC violation, an election law violation, by using hush money payments to as an illegal campaign contribution, essentially. Now, this question was sent to the DOJ, I think to the FEC. They decided they weren't going to prosecute this case. So how can the jurors, who are just jurors, and because Trump was in charge with an underlying crime, are the jurors in a position to decide whether or not something's a crime when the people who are charged with the responsibility of charging an underlying crime decided not to charge the underlying crime? How does that work?
Yeah, I mean, it's a little more complex than that. So
more complex than that.
That's not complex.
Please enlighten us.
So 12 jurors, like one's like, a dog groomer is going to be able to figure this out.
So, here's the thing. Prosecutors make a couple of decisions. Prosecutors make a decision if a crime was committed. That's decision one. Decision two, if a crime was committed, is this defendant the person who committed the crime? Those are simple. Those decisions are made thousands of times a day by prosecutors all across the country. The third decision is the difficult one, which is it appropriate or suitable for the government to charge this person with a criminal offense, given the circumstances of everything? And I mean, if you want an unbiased opinion, let's be real here, David. The Department of Justice charging a former president with a hush money payment would just, ooze even more of political motivation than the allegations that have been made against Bragg in this case. And in certain circumstances, you just let the dog lie and don't go ruffle the feathers. Now, the Alvin Bragg in the district attorney's office in Manhattan has had a different philosophy, which is part of prosecutorial discretion. I mean, in my career as a prosecutor, there were times where I thought that somebody might have committed a crime and decided that in full, it wasn't worth it. It wasn't worth the resources. It wasn't worth what it would take to go through a case, and that, whatever happened, and it was time just to move on. Now, again, this is the biggest stage probably in the history of criminal prosecution. And you're right, Puppet. Now we have dog groomers and 11 other people trying to decipher whether a federal election violation did occur. But that's the faith we put in the jury system.
So, but still, isn't it unusual, I guess, in a case like this? Because the same reason why you said the Department of Justice, you don't want to, it doesn't want to look biased. Isn't it unusual then, though, for Alvin Bragg, when they decided not to bring this case, for him to go, well, it would have seemed political if they would have actually charged him with it, but they didn't charge him with it, but that's okay. We're going to allege he did it anyway and bring it to a felony. Wouldn't a more responsible thing have been, let's just charge him with the misdemeanors? But he couldn't, though, because the statute of limitations had expired. The only reason this case could even have been brought is if there was this underlying crime that you really have to kind of make a stretch to get to it. And I guess what I'm suggesting is, how does it not destroy the credibility of this court to make that stretch just to bring? I mean, there's some cases that are not worth bringing. You said yourself. Mm-hmm. I mean, why bring a case that nobody wanted to touch the underlying crime and then try to prove that when you can't even really prove the primary case with the business records? That's the part I'm confused about.
Well, if you want to pipe in the battle hymn of the Republic, I mean, the very fundamental basis of our justice system is that we as the people decide if people have violated our laws. That's why we have juries in the first place. And there are some prosecutors who hold to the ethical standard of, if a prosecutor believes in good faith that they can obtain a conviction based upon admissible evidence, then they should charge that case and present it to a jury and let a jury of the president's peers, however you can define that in Manhattan, decide if he did it or not. The problem is when prosecutors use their discretion too much, they are now playing judge, jury, and God on who should go into the system. So it's a tough balance that there's no way to get it, perfect. Now, in the same sense, the Manhattan District Attorney's Office has, taken a swing for the fence on this one. And you're right that it's not typical when one legal entity says that they don't believe a crime was committed, that somebody says, thank you, but no thank you. I'm going to decide that they did, or ask somebody else as a second opinion. So it's just part of the menagerie of chaos that this case entails.
Yeah, especially when it's the federal government saying we're not going to bring this case, and the defendant is the former president of the United States and the presumptive Republican nominee for the 2024. I mean, this is just, if as a lawyer, regardless of how I feel about Trump, this isn't a case that I would seek to prove or even present, especially considering what you said before. You said there's a duty to, if it's the people's case, and if you think you can prove the elements, you leave it to a jury to decide. I think every legal expert that I've spoken to since this case created, and I think Puppet counts as a legal expert, I think. Everybody thinks that this case was kind of weak from the start. And even the media, even the left-leaning media suggested that they wanted this case to be brought last because they felt like it was the weakest case out of all the cases. I mean, we had the classified documents case in Mar-a-Lago, which seemed to be the strongest. You had the January 6th case, or whatever they're calling it, in D.C. And then, of course, we have this Fulton County case, which seems it's pretty significant. This was considered to be the weakest case, yet it's the one they brought. So, I don't know. It's what do you say, Puppet?
Because they could bring it. They brought it because they could bring it.
Well, that's
obviously the DOJ passed on this because A, it would look really bad, and B, they know that there's been so much hush money paid in the White House and in the politics that it would just open Pandora's box. Okay.
No.
So then, but at the same time, they can't help themselves but go after Trump. So if some prosecutor picks it up, then we can't really do anything about that. And so then, so all of a sudden some New York prosecutor picks it up and who, has vowed to get Trump, and, you end up with these cases. But the problem I have with the whole thing, whichever side of the coin you are with Trump or not Trump, I think that this whole kind of shenanigans, an ex-president getting indicted for these kinds of crimes, which everybody knows this happens all the time in Washington, whether he paid the hush money and didn't pay the hush money, or what he was in the account, or which line item they put it on the budget, any of that stuff is. And it's never been done. It doesn't happen, but it happens all the time. And they're doing it to Trump. And it undermines the credibility of the whole system. It undermines the credibility of our election system. It undermines the credibility, especially being that this president is now also happens to be the candidate for the opposing party for the president of the United States. It's just ugly. And it just looks exactly like what it looks like, which is potential election interference, which is exactly what they're bringing the case up for.
Well, yeah, that's the kind of hypocrisy on it. A lot of people think that the case in itself is election interference, but the case, one of the underlying theories is election interference. But Ryan, let me ask you this. Based on, there's a perception that Judge Merchan has not been objective. He has kind of been more lenient with the people's case. He has been more tough on some of the objections from allegedly from Trump's team. This is what people have been saying on the right.
Is his daughter's connection with
right? Well, there's that stuff to the appearance of impropriety stuff and the recusal question, but we'll put that aside because that's a much bigger topic. But when he was charging the jury, a lot of people were questioning there was a lot of objections being made to the kind of the way the jury is being charged. It almost made it as easy as possible. And Trump even came out after this. He said Mother Teresa wouldn't beat this charge. The way it was presented to the jury was seeming like they're like, look, you don't even, nothing is evidence. It's really up to you, and you've done a great job. And it was just sort of like buttering up the jury in a way like he really wanted the conviction. That's what people on the right were saying. From your look, you have a lot of trial experience. What do you think, not just today with charging the jury, but I do want to know specifically if you felt like there was anything unusual about that, but his conduct throughout the hearing, especially with that Peter Navarro testimony and him getting, stopping court and putting on this big display. Has this judge, because the assumption is that there's some bias, has this judge's behavior been anything out of the norm from your experience in doing trials for so many years?
Nothing really stands out to me, based upon my trial experience of 19 years now at this point. There's a couple of things. The first is, although the instruction on the crime itself is one that had to be created, most of the other instructions are standard instructions that are approved by the Supreme Court of whatever jurisdiction. And yes, it is a lot of repetitive items. It's a lot of telling jurors, you're a judge of the facts. It's your decision to decide credibility. I think the instructions sometimes go over the top to reinforce to jurors that, in essence, they're judges of the facts, and a jury gets to decide what facts are credible. And the instructions go out of their way sometimes to try to give the message that the judge doesn't care one way or the other. And a good neutral judge is not supposed to care, and they're supposed to call balls and strikes just the same for whatever team. I think the judge's outburst during the trial was sort of a culmination of frustration that happened on both sides. You get parties that are advocating for their side. You get witnesses sometimes that come in and do appear to have their own motive. And I can't think of an instance where I ever saw a witness turn to a judge and smirk or laugh while a jury's in the courtroom. I mean, that you can't have that type of behavior. I think, was the judge more lenient to the prosecution or the defense? I mean, he made rulings on both sides that made each side happy and each side not. I mean, I think it's the way that you tell if somebody's being fair in this adversarial system is, frankly, if neither party is totally happy with the decision maker.
So one other thing people are pointing out today was the fact that the jury did not get the instructions. There were difficult instructions. There were, I think, 18, I forget how many pages they were, but it was complicated. And the jury wasn't given the instructions. And during deliberations, they kept having to send questions up. And I think at one point the jury was brought back in, and the judge decided that tomorrow morning he's going to reread the instructions to the jury. Now, we've had an entire day of deliberations, well, half a day of deliberations, and then tomorrow we're going to have another day of deliberations based on these instructions. What do you make of the jury not being given the instructions in their deliberations? And what do you make of the fact that they've asked questions? And lastly, do you think the fact that they're asking questions and the fact that they're still deliberating, does that make you think that they're leaning one way or the other?
So I learned a long time ago to never read into a jury question. I mean, at its basis, jurors are those who either want to be on a trial, which if you ever want to serve as a juror in a lengthy trial, we could have a discussion on, or those who are not smart enough to get out of trial. So it's standard practice in New York state courts to not provide instructions. That to me is an absolute error. It's nothing that can be overturned on appeal, but you have on this jury, 10 out of 12 of them have no legal background or aren't lawyers, and you're going to ask them to make decisions based upon really technical law. It is a mistake to not give them instructions, but I guess they do things up north different than we do them here in the South. I think that the jury questions, although you can't read into them one way or another, the only thing that the jury questions tell me is that they're at least having enough of a spirited debate to want to ensure that the testimony of Pecker and the testimony of Cohen is what it is. Oftentimes you have jurors who take notes and they focus on things differently. So at least they're trying to get on the same page, which is encouraging, but it doesn't tell me whether or not they're more or less likely to convict. And on the deliberation piece, I guess we're all going to watch our specific news channel and see the minute by minute ticker. I've had juries come back guilty in 6 minutes. I've had juries come back in 17 hours. Look, 12 people got to agree on something. And that's hard, especially today, to get that many people to ever agree on the same thing.
Yeah, a lot of people think it's going to be a hung jury. Puppet, what's your thought, I guess, after what you saw today? And do you have any questions? Do you have any dummy questions for our resident attorney, Ryan? I think he's shocked.
We've done such a good job. We finally silenced.
Yeah, he I think he fell asleep.
I think I'm having a little,
his eyes don't close when he falls asleep. That's the problem.
I'm having a little internet issue. I'm having a little internet issue. Sorry, Jim.
Sure. Makes sense.
Yeah, I mean, I'm making some hush money payments as we speak. That's what I'm doing.
Yeah. Well, just make sure you categorize them appropriately as legal payments, which is actually what they are.
Well, are you categorizing them properly, David? You're my lawyer.
Yes, if you
You're
pay
my
me for
counsel.
legal fees, I'm going to record those as legal fees. That's usually how it works. All right.
Should.
So this thing maybe ends tomorrow. Maybe it doesn't. I don't know. I have three things, and this will be the last question I ask you, Ryan. I feel like, and this isn't probably just more of an opinion question than a legal question. I feel like an acquittal would certainly put a lot of cold water on all these other cases that are pending out there. After one acquittal, it's going, even though it's not double jeopardy, it's going to feel double jeopardy-y for him to continue to be tried for crimes after being found not guilty in New York. Any trial that comes after this one, if he's found not guilty, is going to seem wrong. Even if it's a totally different case, I think Americans are just going to be like, you already tried him. He was found not guilty. Leave him alone. Let's move on. Regardless. Now, if it's a hung jury, I think that's probably a better than a guilty verdict, clearly, for Trump. But I think at that point, my opinion is the media is going to say he wasn't not found not guilty. And so that'll create its own narrative. And trust me, that's exactly what they'll say. They'll use the double negative and everything. But I think I think what they'll say is, well, we're not going to retry this case yet. Let's see what the other cases do. And I think this thing just gets punted down. We're back in law in all the different cases, and everything goes on as it was. And I think if he's found guilty, certainly we go right to appeal, and the media will have their day with it. I don't think it ends up hurting him. What do you think the outcome is going to be? And then what's your take on whatever outcome you think will, I guess, arrive when the jury's done deliberating?
So I will remind you of our last conversation when I told you a hung jury was going to occur, and I've doubled my bet on that.
All right.
On everything that's gone back and forth. You know, as it relates to what's the outcome of this from a political side, candidly, the president wins no matter what. If he's acquitted, then he's vindicated. And I'm sure we'll hear that once or twice on Truth Social and X in every street corner. If it's a hung jury, then, you know, both sides are going to attack it and play it that, you know, he was guilty, he wasn't guilty. Honestly, I think if President Trump is convicted, he's going to sell 5 million T-shirts with a copy of the verdict form on the front of it, just like the booking photos. So, you know, at the end of the day, you know, there's arguments that this may be politically motivated, even if it's not, you know, wherever you stand on that issue, if it is or isn't, it's definitely going to be politically significant, especially going into the summer and going into the fall.
Or at least politically discussed. I mean, it surely will be part of the zeitgeist discussion of the rest of now to November. That is for sure.
Well, and it's interesting, Puppet, because even today, Jill Biden was out on national TV talking about wanting to focus on the character of people. And, you know, as that goes, not to open Pandora's container about where that leads to, you know, this whole thing is going to really determine not only the presidential election, but I think, you know, really strong conservatives and really strong liberals, and they're just going to continue to pull to their opposites.
No, for sure. I can tell you this, if nothing else, I can guarantee that if Puppet was on that jury, they wouldn't be able to call it a hung jury. That's for sure. So maybe let's call it a mistrial.
I'm going to leave that one alone.
Yeah. Ryan, I appreciate you so much. All the information you've provided. I think our viewers are really going to appreciate the no BS take on what's going on. We're going to have you back. We're going to continue to talk about this because, look, even if, like I said, there's a couple different ways this goes, but I think there's not going to be a shortage of legal analysis necessary between now and November. So I appreciate you so much and your experience and your willingness to come on the show. Is there any follow-up you'd like this audience to do? Do you want them to check out SheffieldLoman.com? Is there any initiative you're working on? Anything you want the audience to follow up on after they leave this episode thinking, wow, Ryan's a great dude?
Well, hopefully they'll remind me, they'll remember me of that picturesque description you gave of the briefcase walking into the hallway. We're always here at SheffieldLoman.com to help you with your litigation and business needs, estate planning, and real estate. So we're just happy to be a part of the community and serve. And now I can say that my day is complete, having had a 25-minute conversation with a puppet. And I appreciate you as always, David.
Absolutely. Puppet, I think he likes you.
Yeah. Nice to meet you, Ryan.
Good to meet you.
Well, thank you guys so much, and we'll be talking again real soon. And thanks everyone for watching. And look, if you're watching the video, you have some questions, put it in the comments of the video. We're on X, we're on YouTube, whatever platform you're watching us on, whether it be Rumble. I can always answer those questions for you. We can reach out to Ryan. He's on X, and he can answer those questions for you. And, if you just want to mess with Puppet, please do. So put your comments below. Share this with your friends, as always. And don't forget, whatever platform you're doing, if you like it, share it, subscribe to it. Whatever, just tell everyone how great it is. And what's that, Puppet?
I said, hey, Puppet Nation, the flea stops here. Follow me on X.
That's it. Follow him on X. But anyway, guys, thanks everyone for watching, and we'll be back doing this again real soon. Good night, everyone.